This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
This relates to an illegal search which was carried out at one of the offices of the writ petitioner on the 9th of June 2026.
In connection with which criminal prosecution?
Yes. But this appears to be under a Hare Street police station case where the allegations primarily are that after the last election,
Mr. Dotto, please
Yes.
come to paragraph 10 of your writ petition.
yes, my lord. Yes.
Already one civil revisional application in
No.
connection with
No.
same proceeding is pending before the coordinate bench.
CRR is only
2240 of 2026.
CRR is only in connection with a section 179 notice, nothing else. So that will not take care of.
If it is in connection with same FIR, then in other matters I am also following that you should approach the coordinate bench. I will release the writ petition with an observation that since this writ petition comes out from the same criminal proceedings and FIR, so the writ petition stands released in order to avoid divergent views.
Milord, may I say this, Milord? But the Supreme Court, Milord, has dealt with this issue. But Supreme Court says that, Milord, in a case where, Milord, the allegation is that the police is misusing the power, remedy is by way of mandamus. But I cannot pray for mandamus under 482.
No, this I am not saying. I am saying that this writ petition to be released and be placed before the regular bench.
Yes.
Before the coordinate bench. The bench which is in session of criminal divisional application.
Could I say this?
Either bench, my lord, to be
With
So that
respect,
in order to obviate divergent views.
with respect, Milord, may I say this, Milord? But under our rules, Milord, your lordship may release a matter for personal ground. Under our rules, Milord, if your lordship feels that some public interest is involved in the matter, Milord, your lordship may direct the matter to be listed before the public interest litigation bench. In a case, again, as per our rules, if your lordship feels that this matter should be made returnable before a division bench, because the very important questions of law are involved, then your lordship may release the matter with a request to the Chief Justice to place it before a division bench. Kindly pardon me, Milord, for saying this, Milord. Possibly, Milord, the rules will not permit, Milord, a writ court to direct a matter to be placed before a coordinate bench or vice versa.
It is being regularly done nowadays. Because of 226 criminal jurisdiction as well as CRR matters are.
Now, please consider, Milord, what is my prayer, Milord, in the CRR?
No, Mr. Dotto, there is a difficulty. Because here All India Trinamool Congress is the petitioner.
Right.
Now, General Secretary of All India Trinamool Congress has already approached coordinate bench in connection with CRR number 2240 of 2026.
Yes.
In connection with a notice issue.
Right.
Now, out of the same criminal proceedings and FIR, search and seizure operation is under challenge. So let there be.
Search and seizure operation is not under challenge.
In a manner it was done, it is under
Yes.
challenge.
Yes.
So it is in connection with the same FIR.
But the FIR is not under
So
challenge over there.
and whose house was searched? All India Trinamool office of petitioner in CRR 2240/2026 was searched.
True.
So therefore, let these two matters be heard together as an analogous.
Because these two matters will
Otherwise, there will be divergent orders to be passed in connection with same proceeding.
the divergent orders need to be on the same
I
subject.
would not have hesitated to take up this matter had there been no order passed in CRR 2240 of 2026. Today, CRR 2240/2026 is taken fast and order is passed. This is offshoot to this criminal prosecution being Hare Street Police Station case number 98/2026 dated 27th May 2026.
May I say
If
this?
I am not wrong on facts.
Milord, if when Milord the question of Milord divergent view comes, if Milord two courts are approached on the same subject, where an FIR cannot be treated as a subject over here. But I can understand, Milord, 179 notice is under challenge in CRR, and I challenge another 179 notice in the same case.
So what is the harm in approaching the coordinate
But
bench?
but that will be, Milord, quorum non-judice. Your Lordship cannot confer jurisdiction on the
And
482.
your lordship will not, greatest of respect, my lord, your lordship will not, my lord, your lordship will making the
Milord,
observation.
your Lordship may,
I
Milord,
would humbly
even
submit,
Milord,
I would
Milord, if
humbly
you,
submit, my lord, an observation that one could shoot here, not that particular could shoot here, my lord, your lordship can observe. Then, my lord, it's entirely on the honorable chief justice to decide whether, my lord, your lordship or the other.
may I say
It
this,
should be
Milord?
one.
Milord, just for the present, recollecting Milord Prakash Chand's case, where Milord the Supreme Court was considering under the Rajasthan High Court rules as to whether the Chief Justice can, Milord, take out a matter, a particular matter, from Milord the list of another judge, where the answer is no. Even with respect, going by our rules, to my understanding, I may be wrong, that means even the Chief Justice cannot take out this matter from this court. Your Lordship can release it for XYZ reasons. That's a different thing. But Milord, directing that this matter to be placed before another learned judge, possibly Milord is not Milord.
Issue. In the writ petition, search and seizure operation conducted on 9th June 2026. 9 June. 9 June 2026. By the concerned respondent authority, especially the manner in which such search and seizure operation was conducted is assessed by All India Trinamool Congress.
This is the order which was passed, my lord. They have possibly not annexed with your lordship.
In CRR matter.
Yes.
Stop. While considering the issue involved in this writ petition, it appears that All India General Secretary of General Secretary of All India Trinamool Congress preferred one criminal revisional application being CRR number 2240 of 2026 in connection with identical criminal prosecution which is connected to Here Street Police Station case number 98/26 dated 27th May 2026. And coordinate bench passed an order on 11 June 2026 on the aforesaid criminal revisional application. Stop. It is averred in paragraph 10 of the present writ petition that General Secretary of All India Trinamool Congress was subjected to repeated coercive investigative measures, including issuance of notices requiring his appearance before the investigating authorities, propriety of which was questioned in CRR 2240 of 2026. Next paragraph, alleged search and seizure operation on 9 June 2026 also relates to Here Street Police Station case number 98 of 2026. Therefore, this court finds present writ petition needs to be heard by the coordinate bench, which is in session of CRR 2240 of 2026, in order to obviate divergent views. Next paragraph. CRR 2240 of 2026 was heard by Honorable Justice Kaushik Chandra, and an order was passed on 11 June 2026. Next paragraph. Hence, the present writ petition stands released and be placed before the Honorable Chief Justice for assignment.
But your Lordship may kindly record my submission. I made some submissions on whether this could go before another judge in CRR, sitting in CRR, or this should be heard together. Because your Lordship may release matters made on personal grounds, no doubt about that.
No, not on personal grounds.
So that's what I'm saying. But since your Lordship is not releasing it on personal ground, according to me, Milord, this has got no connection with the CRR.
উপরে একটা দিয়ে দেবে একটা জায়গায় যে মিস্টার দত্ত learned senior advocate representing the petitioner, however, submits, considering the issue involved in this writ petition, releasing of writ petition for hearing by the for hearing of the same by the coordinate bench, which is in session of CRR 2240 of 2026, is not necessary, and writ petition may be heard by this court.
And Milord,
In this context, my lord, I shall make one submission. Kindly take up the order once, my lord, page 3.
Page 3.
Second paragraph.
And also, seizure also is subject matter investigation, the particular case.
The first part of it.
First paragraph.
No.
Second paragraph.
Paragraph, the first part of it.
date কত রে? Date. No, date.
11.
Mr. Mitro, learned Advocate General representing state respondents, at the same time has drawn attention of this court to the relevant part of the order dated 11 June 2026 passed by the coordinate bench on CRR 2240 of 2026, wherein it was observed by the coordinate bench that for the purpose of securing or recovering any document relevant to the investigation, the investigating agency remains at liberty to resort to search and seizure or to adopt any other measure permissible in law.
So this is 11th of June.
And
My
ঠিক আছে।
cause of action is on 9th of June. ঠিক আছে?
ঠিক আছে।
But it relates to search and seizure.
Look,
Stop.
this paragraph did not give a charter to the police to break all BNSS laws and then cause the search and seizure.
Yes,
This is not a charter.
this order was passed on 11 June.
Yes.
So this
And
can,
thereafter,
yes, so this order cannot be stretched to 9 June 2026 incident. But this court is of the view that since it relates to the same criminal prosecution on FIR, let the issue be heard along with the civil revisional,
Now the
criminal revisional application.
question is, can a criminal division court pass a mandamus?
বাবা নিতেই হবে।
Yes.
Because my lord, under 482 of whatever it is,
Ah,
this is not correctable, my lord, under the
Sure.
criminal jurisdiction.
Read it soon.
But your lordship has not looked into the decisions that I have brought, my lord. But if this was the hesitation in your lordship's mind, but I have it right now with me. I have those judgments.
No,
From
Mr.
1970
Dotto, in order to avoid multiplicity of or
multiplicity,
divergent
my lord.
views, no.
Milord, from 1970 till Niharika. But Niharika is often quoted. In Niharika also says that in a case where the police violates the CRPC or BNSS, of course then BNSS was not there, the remedy is by way of mandamus.
Niharika
It
does
is
not
from
say, my lord, with
1970,
respect-
1980 to 2021. Therefore, my lord, relegating me before my lord, the Criminal Revision Court, in my very humble understanding and submission, would be contrary to what the Supreme Court has laid down. Because the Supreme Court has considered that if somebody is affected by an illegal search, where will he go? Should he go before the criminal jurisdiction of the High Court?
Court has
Supreme Court said it has to come before the
Court has
mandamus court. This is 1970
No,
on.
since two separate issues are there from emanating from the same criminal prosecution, I
But
think
it is
that it should
with
be hard.
respect to with
Matters are also, Mr. Dotto, what you are saying, matters are also being regularly assigned to this court, CRR matters.
Millard, it is being assigned to your lordship, Millard, provided the honorable judge, Millard, may feel that for some reason of the
In
court,
my own way, I have to try assign reasons. If you are not satisfied, then the liberty is there. You take steps in accordance.